Part 3, Section 17. As a GAL in Wyoming, it is very possible that you will have a case with a Native American child and family. In these cases, a GAL must become familiar with the Indian Child Welfare Act. The Indian Child Welfare Act is a substantive federal law, the purpose of which is to preserve Indian families and culture. ICWA, ICWA, establishes strict guidelines for when an Indian child is involved in a child custody proceeding, including any action involving foster care placement, adoption, or termination of parental rights. Because dependency cases very often involve foster care placement, it is essential that you are well versed in ICWA's requirements. Failure to follow the law's requirements can result in invalidation of the proceedings. If ICWA applies to your case, see the Bureau of Indian Affairs Guidelines for State Courts Indian Child Custody Proceedings for guidance on ensuring compliance with ICWA's many requirements. Remember that several of ICWA's provisions are jurisdictional and can be raised at any time during the proceedings. As a result, it is imperative that ICWA compliance starts at the beginning of the case, so that permanency for the child is not disrupted at a later date. Any party can bring a petition to invalidate state court action taken in violation of ICWA. Therefore, it is critical that the court makes the necessary findings under ICWA and that the court orders reflect the correct findings. At the outset of the case, the court must determine if the child is an Indian child for purposes of ICWA. An Indian child is defined as any unmarried person who is under age 18 and is either a member of an Indian tribe or is eligible for membership in an Indian tribe. If the court determines that the child is or may be an Indian child, the state must notify the child's tribe. If tribal affiliation is unknown, the state must provide notice to the Secretary of the Interior. When in doubt, provide notice to any possible tribes as well as the Secretary of the Interior. You should ensure that the notice has been sent via certified mail with a return receipt required, indicating that the tribe has received the document. Best practice dictates that the return receipt, a green card, be filed with the juvenile court. If the case involves an Indian child who resides on the reservation or is a ward of the tribal court, ICWA provides that the tribe has exclusive jurisdiction over that child. In this situation, a non-tribal court may order a child removed from the custody of the parent only to prevent physical harm to the child. This order must terminate when there is no longer a danger of physical harm. If you believe that your client resides on the reservation, it is necessary to conduct an investigation into such residence to determine whether these provisions of ICWA apply. If the case involves an Indian child who does not reside on the reservation, the state court and the tribal court have concurrent jurisdiction. In these cases, the action may be transferred to the tribal court if transfer is requested by the parent or by the child's tribe. The state court can maintain jurisdiction if the parent objects to the transfer, if the tribe declines the transfer, or if there is good cause showing why the transfer is not appropriate. Good cause is not defined by ICWA. The Bureau of Indian Affairs Guidelines do provide some situations in which a court might find that good cause exists to decline transferring a case to the tribal court. For example, if no tribal court exists, or if the request for transfer was made late in the case and well after notice was received. Furthermore, if the child objects to the transfer and the child is over the age of 12, or if it would present an undue hardship to the parties or witnesses in the presenting evidence, it could be considered good cause. Finally, good cause may be shown if the child is over the age of 5, has had little to no contact with the tribe, and if his parents are not available. If your case involves an Indian child, the court must make specific ICWA findings at various stages of the proceedings. Before the court removes a child from his or her home, the court must find by clear and convincing evidence that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. A qualified expert witness must testify regarding the damage to the child. As a GAL, you need to assist in or identify a qualified expert and make sure the expert provides adequate testimony. ICWA does not define what qualifies an expert witness, but again, the Bureau of Indian Affairs guidelines provides some guidance. A member of the child's tribe who is an expert in the family organization and child-rearing practices of the tribe may be considered an expert. A non-Indian expert who has substantial experience in providing services to Indian families and knowledge of the Indian culture and family practices of the child's tribe may also qualify. Finally, a professional who has substantial knowledge and experience in his or her field may be an acceptable expert. The court must also find that active efforts have been made to prevent the breakup of the Indian family. Although not defined by ICWA, the active efforts requirement generally means that the agency or the state must provide more than the reasonable efforts required in non-ICWA cases. As GAL, it is important to carefully review each court order prior to approve to ensure these key findings are included. ICWA establishes specific placement preferences for an Indian child who has been removed from the home. The overarching requirement is that the child be placed in the least restrictive, most family-like setting that will meet the child's needs and that the placement be nearby to the child's home. ICWA lists placement preferences in descending order, first with a family member, next in a foster home licensed or approved by the child's tribe, and last in an Indian foster home licensed by a non-Indian licensing authority. In Wyoming, the non-Indian licensing authority would be DFS. ICWA does not specifically recognize placement in a non-Indian foster home. However, it is generally recognized that if none of the other options listed are available, then placement in a DFS-approved foster home is appropriate. If the child needs institutional care, the institution must either be operated by an Indian organization or approved by the tribe. ICWA also establishes specific placement preferences when the goal for the child has changed to adoption. Those placement preferences are first with a family member, then with another member of the child's tribe, or else with another Indian family. Before a parent's rights can be terminated, the court must find beyond a reasonable doubt that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. The termination proceeding must also include testimony of a qualified expert witness regarding the damage to the child. The court must also find that active efforts were made to return the child to his or her family. State courts must give full faith and credit to tribal court orders. In cases where state and federal laws are inconsistent, ICWA states the highest protection law will govern.